All right, abusia minchia na misan so emu akwaba emfa wo emra ye channel so that's why ye be media jeche be so ase ene de dika wani twa channel so ni di kwan so ye be so ase be subscribe e de amai bobo notification bell no so for more podcast updates. Na ene ye maame ye former chief justice ye maame Gertrude Esaba Torkornoo ma geti abusia amanebo ne atwemu echese mami e claims makoma ko 7 e de akodan ECOWAS court. Yes, said ni fa hodie pa de ye tetia so ewo oman Ghana mu ama ya fa kwan bi so ayi no e de afiri ho ne kwan na omofa so ayi no as a chief justice no abusia na enye ne kwan so enti ope $10 million compensation edi afri Ghana aban ho abusia after say yes or this answer me ekopie mu ewo ECOWAS court Abuja abonten so no che say ECOWAS court abone nsem no saa 7 claims o de koyi ya boni na agu na ya boni na agu ye no anso ha ma mi asan aba abawura mu ewo Ghana ye high court and as well as the supreme court asa den nsem no de akwa dan attorney general abusia we dia ma mekasa wa me ma mekasa enye tenten pese yeko na ekokotie ensem no mu ankasa enkyere mu. Yes, yentie ensem no mu yie se na be ya ye beti ase ebi ameka no abusia me hu ensem ne ka yie pese ya yeko na yetie ensem a chese akoso ne siye ewo ECOWAS court ene ya maami baabi a o chese obedru o my Ghana mu no wasan ade asem no akwa wie a sesi chese damages a abusia nsem na no odin mitumi kanida yenko na yentie na yenkyere ya adwen that's why be media jeche be so ase ene de kodi to channel so ni di kwan so bomodi an so be subscribe dey my bobo notification bell no so for more podcast update be media jeche be fasa konya we so ado bibiara ase since day one abusia mo na ma support ye mo na che say maboa ye am ya bedu sam pepe so say ye ka so bo ade on hira mo o ma na adom no enye kase e wo mo so mo ma yentie na e course so abra lawyer Martin Pebu ene ni crew ebetina ase che so mo de ensem no mu ankasa enkyere mu atudwa
Asasi radio na it's happening in reality ni say your maame Torkornoo ekofale application bi na ni nyina ya abla ECOWAS dismiss ne ensam no efiri o court no na say oba Ghana was file fresh application say ankomo review enano ada court ebuaya o de ba o review na busua ene dey and every 27th of June, we had to screen this one. Former Chief Justice Gertrude Torkornoo has withdrawn her application for review of a Supreme Court ruling consolidate 2 of her cases pending before court. Now, Abusia, Nina said, Mami Torkornoo, on say, and some baby economy, they are using a marana and a dear Juma. And she say, no, why withdraw because was our pending cases out in the Supreme Court crash shocking because Attorney General Cracker said the Supreme Court should make sure or posi against it. Abusia nti fast forward and quote details on TV3 lawyer Martin Pebu any attitude for any painful be Eddie Marano echirichiri nsemu. Stay tuned, stay connected.
There are various aspects of this conversation we can have. This is just the beginning.
Overzealous legislations.
This week we got this notice from the Deputy Attorney General regarding thank you.
Yes.
Regarding the ruling of the ECOWAS court. This is it. Quickly. And Justice Shems, I put this out earlier in the week, that the ECOWAS Community Court has dismissed all of the 7 claims which the former Chief Justice, Leadership Justice Gertrude Torkornoo brought against the Republic in respect of a leadership's claim of $10 million damages. The court held that, quote, in light of the court's conclusions that Ghana has not violated any of the applicants' rights under the Africa Charter as alleged, the court makes no decision on reparations. And this is the proceedings as we monitored. 1. And specific to Justice Torkornoo's case per the Africa Charter on Human Rights. The reason why there was a demand for the $10 million damage. 1, the suspension and removal from office were arbitrary and in violation of her right to a fair hearing and due process. A specific reference was made to Article 7 of the Africa Charter. B, the inquiry committee was illegally constituted and affected by bias. That's the second claim. The third, that she was denied access to a judicially reasoned opinion of the prima facie determination and the inquiry committee report in violation of her right to information. That is Article 9. D, the process violated her right to dignity and protection from arbitrary treatment. E, the removal violated her right to work. F, the conduct of the respondent breached the principle of less penance. G, compensation for $10 million for moral and reputational damage. And this was the determination of the ECOWAS court. Government of Ghana via committee fulfilled its obligations of fair hearing, number one. Government of Ghana did not violate applicants' rights to be heard under Article 7 of the Africa Charter. Prima facie determination did not violate fair hearing principle. It is a filtering mechanism. So, this grounds without merit, only courts in Ghana that have jurisdiction over procedural matters of quasi-judicial bodies, and the ECOWAS court on the matter of the competence and impartiality of Article 146 committee, they declined to review the merit of the committee's findings. They said they don't have jurisdiction over that particular matter. Suspension from office by president did not violate the applicant's right to work. That's the ECOWAS court's verdict. The applicant was not unfairly and arbitrarily removed from office as Chief Justice of Ghana. Decision to focus on single petition for her removal was not irregular. And they also say, court rejected arguments that bodily search, failure to have family present during hearing, and choice of venue were a violation of her right to dignity. And then also the court held that bodily search was reasonable and proportionate. And finally, the applicant did not make an official request for committee report. Hence, the court does not find her rights violated. Start off with you, Mr. Anu, on this, quickly.
Well, I'll be honest with you. This is one of the national level incidents that I always had some kind of disquiet about. Throughout, I kept quiet because I wasn't clear in my mind whether I was sufficiently apprised of facts to draw a conclusion. And I think I was also worried about the trajectory. We had started earlier with removal of electoral commissioners. We had escalated to chief justices, and I was wondering what next. I think that this, for me, was a very unfortunate milestone in the history of our nation. I think that there are lessons to be learned that must be learned well. My brother Samson Ladianyini gave me some, legal understanding of the background that made me think differently about the scenario. I think it's good that she's exploring all the opportunities of venues. It's good to see the feedback. It probably gives us more confidence in watching that I felt a lot of disquiet. I was not quite sure where.
There was a private conversation that we had, and then at some point, sometime within the week, you espoused your position on it. But this is, at the time, I hadn't seen the ruling and aspects of it, so I could not speak to what you were asking. But clearly stated here is the position of the court regarding the number of the reliefs that she was seeking, including the said payment, that this committee that was established actually fulfilled the obligations of the fair hearing. That's number one. And the two, that the government of Ghana did not violate applicants' rights to be heard under Article 7, because she went under the Africa Charter. Then this matter of the prima facie, which you had mentioned some time ago, the determination did not violate fair hearing principle. It says a filter mechanism. The grounds without merit says only courts in Ghana that have jurisdiction over the procedural matters of quasi-judicial bodies can. And they declined to review the merit of the committee's findings. Also, the suspension from the office did not violate the applicant's right to work. But this one, the matter of the bodily search, the court rejected that argument of the bodily search. The failure to have family present during hearing and the choice of venue were a violation of her right to dignity. You say that description of the process as being hounded out. You disagree?
Absolutely. Absolutely. You see, when you say hounded out, it doesn't represent the facts at all. It's not a good rendition. Yes, I appreciate that as lawyers, we can, and that's the art of persuasion, we use different words and come from different perspectives. But cut to the chase. What we are confronted with is a case of a Chief Justice who spent over 300,000 Ghana cedis illegally. You don't call that handing out. That actually is an insult to millions of our citizens who don't earn even 100,000 Ghana cedis the whole year. That's an insult. Evans, you earn 100,000 Ghana cedis a year. What is it? Winifred, you earn 100,000 the whole year. It's an insult to millions of citizens. Let's stop this. You see, you can advocate for her. You see, I've been supporting her that as for her right to get the prima facie ruling and the right to be accompanied by at least 2 people, I will always defend it. But you don't go and say somebody who has spent over 300,000 illegally. You trivialize the issue. And you mentioned Sophia Kufu. But we made it very clear to my dearest Sophia Kufu that, yes, we support her. I never come here without mentioning her name, at least in the past 1 year. Yeah, a little over 1 year. We've been extolling her virtues. But when this matter came, we pointed out to her that, oh, dear Sophia Kufu, this one, dear, we part ways. And you see there, I can understand why she thinks it's not serious. While she was in office, she also did the same thing.
What do you mean by she did the same
thing? Oh, that thing was there.
What thing are you talking about?
I'm talking about this travel with a relation. So Fekufu did it. Eniyebua did it. The audit report asked Eniyebua's wife to refund some money. It's a public document.
There's specific documentation.
That audit report.
This particular
yes, because this matter, the more you trivialize it, then the more we must state the facts very clearly. Because when you do that, then you are insulting those of us who are trying to hold people accountable. That's an insult. Check the audit report. Eniyebua's wife was asked to refund money. That same breach.
So why wasn't she asked to refund money?
Who?
So your own Sofa
Eniyebu had left office.
So your own Sofa Kufu has made the point. You can't respect somebody in the day and disrespect them in the night.
It's the same principle. Disrespect, disagreement.
Well, the point is,
please.
Kofi, your
no. The point is, when you welcome me, consistency is key.
Which inconsistency?
She said this was normal. How can you just? The audit report in the case of Justice Torkornoo exonerated her. And please, no. We've gone through this. And just like you're saying, when you have these infractions, a refund is necessary. And your beloved Sofa Kufu, who I also respect, says that it does not rise to the point.
It's not for her to say.
It's not for her to say. She has been there. She has been there, done that.
So now let me say, it's not for Sophia.
She has been there and done that.
Just for public
So continue to respect her and agree with her.
This audit reports, which specific audit report are you referring to? Please, hold on. I just want you to.
Yes, Auditor General's audit report. Oh, we had copies. They were shared. It's an audit report. Okay, as we go on, I'll pull it out. Okay, so let's make the point. But that's not enough. So this is what happened. Let's state the facts clearly so that we understand this case. So this is what happens under the Constitution, Article 71, right? Under Article 71. The president determines the conditions of service of Chief Justice, except many people, based on the recommendations of a committee of 5 persons. Then Parliament determines the emoluments of the president, vice versa. But I'm saying that under 71, it is for the president to determine on the advice of the committee, right? So now, just briefly, so that people can follow shortly. The salaries and allowances payable and the facilities and privileges available to, then let's go B, Chief Justice and the other justices of the Superior Court of Judicature shall be being expected, blah, blah. So that's the thing, right? So we're saying that for the Chief Justice to have the privilege to travel with her daughter or her husband, is it in what the president approved? Simple. And the Constitution is the highest law. So the judiciary went and made an illegal policy. Sorry. They went and made an illegal policy where now she can go with security detail, and then sometimes they say when it is, when it is an official trip, then it is relaxed because presumably there will be security there. So I'm saying that the simple argument, what the committee held,
the policy?
The judiciary, they did, the judicial council. Yeah, so we are saying it's an illegality because
because that policy was inconsistent with the provision of.
Thank you very much. Thank you very much. Oh, please.
I just needed a clarification on that.
So 71 says the president should determine. So the point is that if you go and open the Buando report, Akroma, Green Street, all of those reports, what the president approved, did it include travel with your daughter or your husband? Respectfully, no. That is where the illegality comes from. So it doesn't matter that the judicial council went and did an illegality. So for people benefited from it, any Ebua benefited from it, right? And now Ghanaians are becoming wiser. I say, now we've become wiser. People are looking for accountability all over. And they went and discovered it. And some citizens brought it up. And the committee looked and said, it is not borne now. And thankfully for us, even before Torkornoo was taken to court, in the Abronye DC case, Torkornoo held that they cannot give the spouses of the president and the vice president. So she had earlier on ruled that it is not borne out by 71. So the committee was simply adopting precedent that Torkornoo herself has set up. And I'm saying that, please, you insult Evans, you insult Winifred, you insulted millions of Ghanaians when you come and say spending over 300,000 Ghana cedis is a trifling. And I've told you. So you see, from day one, I said, no, this one, I disagree with Sofa Ekufu violently. Violently, I disagree with her. Yeah, she can be lucky that when she did it, it didn't bring her consequences. But the fact that an illegality is
done with others on, anti-corruption. Okay?
It's even a good proposal.
Please. Now, when we talk about these broad things, look, you'd never stop building a nation. You keep going. So as we move, the things we need to do, we add to them. It is unfair and it is defeatist to make it about Ken Ofori-Atta. But the fact about Ken Ofori-Atta is that, one, the system has created a situation that has inured to his benefit. And I said that a year before it happened. Okay, when I told you, Martin is my brother, please. When we argued and finished, later he found out, and then you mounted an attack against the OSP.
Yeah, first I didn't know he was deceiving us.
Okay, so look, sometimes you can listen to what I say and not understand it. I have said, and I said it long before, that the way this thing was going was wrong and was going to inure to Ken's benefit. Two, I said that given the atmosphere that was being created, no serious lawyer would advise Ken to come back. Three, I said that if you have a situation where people are demonstrating against him, his name is being mentioned and demonized, when he has not been charged, you will create a situation where the U.S., it will raise a platform for him to seek asylum. It has happened, it has been granted. The U.S. courts have actually said something.
Not asylum, he's going to green card.
No, he will claim asylum.
No, once he has
you are not listening to me. I said he will claim it. The U.S. government has not given him asylum, but they have strengthened his position. The point I'm making is this is not about Ken. But if you want to talk about Ken, okay, the mistakes within this system is what has given rise to the situation where we are in. Now, back to the
maybe we'll name the legislation Ken Ofori-Atta.
Exactly.
Again, you are making a mistake.
It's very important.
Please, let me finish my point.
As if you're on a political platform.
Please.
As if you're on a political platform. Why do you do this to Ken?
Excuse me.
Why do you do this to Ken?
Hello.
Let's legally present our views.
Thank you.
Why not?
You
have made your point.
Style of advocacy. A style of persuasion.
Thank you very much.
The government of this is that we need to improve the accountability systems which the politicians find a way to game. We have talked about the internal audit agency. We need to do something about it.
Right.
I still stand by my proposal that it will be useful as part of asset declaration, which must be published, okay, require either through law or through the president requiring his ministers to do that as a condition, okay, that they will remain within the jurisdiction for at least a year when they are out of office, so that new people who come can look at what they've done, and then we can decide whether we should be prosecuting them or not. I think it is a step in the right direction. So far, I think everybody agrees with me. The only problem is that they think it's about...
Okay, so this is just the beginning. As I indicated to you, it's a conversation that is meant to bring a certain level of improvement or an additional layer of the demand for accountability. How that will be done, Eduji Tamaklo has pointed to the position of leadership, so that you can even have this legislation and still, if the leader is not committed to getting his people to account, it will not work.
It will not.
Also, there's that bit of the legislation itself bringing some level of commitment or tying the specific leader in place to ensure that his people or the people who he appoints stay in the country and account for their decisions. Thank you, gentlemen. That leads us to the next issue this week.
But Alfred, just 30 seconds. No, just 30 seconds. Because of this, just 30 seconds. Because of this legislation, if it is a case that, for instance, I resign 2 years to the end of my tenure and now travel, how would that piece of legislation stop me from traveling?
If you resign 1 year,
it is the case that once you take an appointment, you can't travel.
No.
If it comes, so
it's easy. Okay. If you resign, you have 1 year. So somebody else goes to check what you've done. That's all.
I see. Thank you. Now, but